We got it. Okay. Good afternoon, everybody. Professor Antron, we have Dave Mendiola.
Present.
Laura Fitzsimmons.
Present.
Hello. Joni Eastley.
Yep.
Chris Jean Kiliani.
Yep.
Jeff Wells.
Hi, I'm here.
Hello. Drew Christensen.
Here.
Rob Tellis. Kate Thomas. Bevan Lister. Commissioner Hall.
Present.
Allison Jaffe.
Can I speak to that? Hang on. Oh, good. Allison is in court this afternoon. She got appointed. She won't, this is a one-shot deal. She'll
Okay.
block out everything going forward.
Awesome. Okay, thank you. And Justice William Maupin. We have 7, but I'm expecting Rob Tellis and Bevan Lister.
Okay, so we have a quorum, but we're still expecting a few people that we.
A couple more.
Okay, so let's proceed, and then as they join the meeting, we'll just acknowledge them so we have it in the minutes. Is that okay? So thank you everyone for being here. We have a lot to do today, so I'm going to make a few sort of directional announcements at the beginning, and then we'll start right in with the public comment. So I just wanted to note before we go to public comment that we did receive one written comment before today. We received it at 8 p.m. last night, and I believe it was circulated to the rest of I received it last night, and I think it was circulated to the board this morning from Carson City. So as we move into public comment, I just want to sort of clarify what my plan is to incorporate these comments into the meeting. So we have public comment, and anyone is welcome to speak during public comment. So Carson City, I will give you like the regular time, which is 3 minutes at the beginning and at the end. And then Carson City has, the nature of your comments seem to be focused on the regulations. And as I understand it, we don't have a plan that's submitted. So we will give you additional time on agenda item 5 when we're talking about the regulations to address your concerns, although I'm expecting that you can do that in a sort of in a limited way. I mean, not in a way of your choosing, but maybe limited to about 5 minutes or so when we get to that part of the agenda. And then Story County, I know, Ms. Langer, are you here for Story County?
Yes, I am.
Great. Okay. So, and obviously I was talking to Mr. Reese. I can see him nodding, so we know that we're talking to each other, but for everyone, the comment that we received from Carson City was from Mr. Reese, who's here. So that's who I was kind of addressing when I was talking about Carson City. Ms. Langer, like Carson, you're welcome to do the public comment at the beginning, at the end, 3 minutes, for 3 minutes. And then since you do have a plan that's on the agenda to discuss at item 9, we'll give you some additional time there, probably about in the neighborhood of 5 minutes, to address concerns at that point. So I just want to kind of outline that to you in particular, so you can kind of use your time in the way that makes the best sense for you, and that we will give you this, sort of 3 opportunities to be heard, beginning and end with the public comment, and then also on the agenda item that's relevant to you. Oh, I do see a chat that Bevan Lister and Rob Tellis have joined us. So I just wanted, welcome, thank you for being here. And I just wanted to acknowledge that before we move into the public comment. And then obviously, if there's anyone else who's here to make a public comment, you're welcome to do so. So we'll just take those in order that we are aware of them. So let's go to public comment. I'm assuming, Mr. Reese, that you want to use this time, but it's up to you.
Chair Trom, thank you for the opportunity. If it's acceptable to you, I will simply direct my comments directly to the portion of the agenda on the regulations, and I'll speak then.
Great, that's great. Ms. Langer, do you want to use this time to make a public comment, or?
I'm going to do the same thing. My understanding is that, well, number one is I don't know that you know it, if you see Exhibit A attached to Mr. Reese's paperwork, that the Story County and Carson City have the same plan because we both use the Public Defender's Office. We're the only two in the state. We're not a Davis situation. And so we're just a little different. So when I put our plan in this week, my understanding is that we're out of compliance. So I don't know how that's going to work. If as Ms. Reba had pointed out to me when I decided to put my plan on, and that she was going to publicly tell everybody where we are non-compliant, and then I would discuss with the group my plan. And I brought witnesses to talk about what we want to do, who the indigent coordinator is, what we think is, why we think our plan works, and certain things that we'd just like to address just to get some direction on. So I think that's the way it's supposed to go, correct?
Well, is that part of the public comment? Because that was,
Right.
Is that what you're saying now? So we don't have to get back into it?
I'm just saying
Ms. Langer?
that, how does it work? So public comment is, when it gets to my section, does Ms. Reba speak first and I speak second, and we just go from there?
I think that's what I had in mind for that
Okay.
of the agenda. I was not, so I had sort of blocked a limited time because in some ways when we talk about that portion of the agenda, the plan, I had sort of blocked that as an update for the board, which I view as sort of an ongoing process between you and the office.
Okay.
So it's more of a check-in. I was not anticipating witnesses, but we can certainly talk about that at that portion. But yes, otherwise I was thinking that we would go to that agenda item. Ms. Reba would make some comments and updates to share with the board and give you an opportunity to speak. And then she might have an opportunity to respond, as well as discussion from the board.
Okay.
So with that in mind, I take it that is the portion of your public comment, and we'll sort of save the rest for later.
Yes.
Perfect. Okay.
Thank you.
Oh, certainly. So I really appreciate you being here, and like so many others, the time that you've invested in this already, and we definitely want to hear from you. Is there anyone else who would like to make a public comment? Okay. So hearing none, and just, I usually do this, but I didn't, other than the written comment that we received from Carson City, is it correct that we did not receive any other comments in writing ahead of the meeting, or no?
That's correct, nothing.
Okay, thank you. Okay, so let's go to number 3 on the agenda, which is welcoming new board members. We have a number of new faces. Some of them we're seeing today, and some of them we'll probably see next time. But Marcy, do you want to talk about our new board members? And then we have a few new members of the office.
Yes, we recently got word that the governor appointed 2 new members to this board. We have Catherine Hall. I don't know if it's appropriate to call you Cassie. Okay. She is a commissioner in Mineral County. She is replacing Lorinda Wickman. She is the NACO appointment, and this will be her first meeting today, and she has her camera on. So it's good to have her today.
Thank you.
Welcome.
And yes, don't call me Catherine. I'll think I'm in trouble.
Our other new board member is Allison Jaffe, who unfortunately could not be here today because she had court, but she replaces Julie Kavanaugh Bill, who was a Board of Governors appointee, and she qualifies as an attorney in the rurals, and she actually is an attorney in Carson City. So we look forward to her being at the next meeting. In addition to the new board members, we have some new staff for the department. Peter Handy is with us today. He is our new deputy director who is replacing Jared Hickman. He has been an absolute pleasure to work with. He comes to us from the Attorney General's office, and we are very lucky to have him. And the other individual that I wanted to introduce you to is Bet. Bet, if you could turn on your camera. Bet Nimra Torres is our new administrative assistant. So if you receive some calls from her, she's working with us now at the front desk, and it's just been a pleasure to have her as well. So we welcome them to our team and look forward to working together.
Yes, thank you. Welcome. Thank you all in advance for serving, and you'll get a lot of perspective today as an introductory meeting. And I've also already been working with Peter, and so I'm so glad that he was able to step in so quickly, and that, I'm sure we'll have a lot more great work with him as well. So, and then we'll look forward to meeting Allison virtually next time. Thank you. Okay, so let's move on to number 4, the approval of the September 1 minutes. Were there any comments or corrections for the minutes that were circulated ahead of the meeting?
This is Chris. I didn't see any changes. I would make a motion to approve the minutes.
Do we have a second?
This is Laura. I'll second it.
Thank you. All in favor of approving the September 1, 2021 minutes as circulated, say aye.
Aye.
Aye. Anyone opposed? Great, thank you. The minutes are approved. Let's go to number 5. So number 5 is getting into some of the couple of big items that we have on for this afternoon. One is the approval of the regulations that has been an ongoing process. So I'm going to hand it over to Marcy on that issue. And then, as you can tell from the agenda, we're also going to be moving into the plan approval, sort of a more detailed update on the plan process and where that is as of today. So Marcy, why don't you bring us up to speed on sort of the minutes, not the minutes, sorry, the regulations, what we have in front of us and where we are.
Thank you, Chair Trom. Chair Trom has asked that I go into a little bit of a historical perspective of the work that this board has put into place so far on these temporary regulations and working towards being permanent regulations. So if you all can remember back of March of 2020, when we had to cancel our initial workshop because of the pandemic of COVID for that first time, and under Chair Bob Kroll's leadership, we sent off our regulations to LCB because we thought the pandemic would be over with pretty quickly and we could move on to those. Those proposed regulations sat with LCB. We submitted them on March 31st, and they actually sat with LCB until around November 20th, 2020, when the board directed that we had received those regulations back and would be setting a workshop. December 2nd of 2020, we held a workshop where we did receive comments on our temporary regulations. And ultimately, we held a hearing on those regulations on January 28, 2021, and adopted those temporary regulations. Those temporary regulations are set to expire November of 2021, and that's why we're here today to adopt permanent regulations. In June of this year, we sent our temporary regulations to LCB. We received those back, and we held a workshop on September 7th. At September 7th, at that workshop, we did receive public comment, and there were some changes that were made to our regulations. From that workshop of September 7th workshop, we did modify section 23 to clarify the screening process. We did change or clarify 39 subsection 10 to talk about reasonable salaries for public defenders, and we made them subject to negotiated collective bargaining agreements if applicable. And we also modified section 40 subsection 10, where we clarified that reasonable compensation for hourly indigent defense counsel should be with a comparable workload. So we did provide that clarifying language. From the public comments that we received from Mr. Reese, we did want to ask that further clarifications be made today, and that would be in section 28 to clarify that where it says sections 28 to 37, it should actually read sections 30 to 40. And the same is true with section 29, where we'd ask to change section 28 to 37 to sections 30 to 40. So we do thank Mr. Reese for catching up on that comment.
Okay, so one minor correction. I think that Marcy made that the workshop and was on September 1st. So just to clarify, we just that's okay. Okay, so what we're here to so today what we have on our agenda are two items. One is presentation and discussion. That's when I would like to hear from Mr. Reese, and then if appropriate, we'll go on as planned to number 6, which is the adoption. So Mr. Reese, if you're ready now, you could share your comments, and I'll give you, about 5 minutes, just mostly as a guideline to kind of keep it brief, but give you time. Go ahead.
Certainly. Thank you, Professor Traum. As you request, I will keep this as brief as possible. First of all, I wanted to thank the chair and thank the board for the opportunity to speak today. On behalf of Carson City does believe that indigent defense is a very important issue, and we support your work, and we would like to see a very robust indigent defense bar. Carson City has a history of providing indigent defense at the Indigent Defense Commission. It was noted that Carson City was essentially doing everything right. We have the state PD as the first level, we have conflict counsel as the second level, and we have private attorneys that we use as a third level. Our goal is really to enable indigent defendants to connect with their counsel as soon as possible. We would like, if an indigent person is arrested and charged with a crime, when he or she is released from jail, we would like to hand him or her a piece of paper with his or her counsel's name on it and phone number on it, so that they can get in touch and enable counsel to represent them effectively. I simply wanted, first I'll touch on a few what I view as housekeeping issues. This touches on separation of powers. It's kind of black letter law that the Nevada Supreme Court has the authority to regulate the practice of law. And many of the regulations that you're proposing and promulgating do also regulate the practice of law. I believe that there's a conflict there. I would like this conflict to be solved so that you could, so that your regulations don't violate the Constitution in any manner. I'll merely note in that regard that the state of Michigan, when they were enacting some of their standards and rules, did run those standards and rules by the I believe the Supreme Court of Michigan, and get the court's approval. In this case, I would suggest that maybe that would be appropriate here. I am sure that you will find a very receptive audience with the Nevada Supreme Court in trying to implement indigent defense standards. That also kind of dovetails into the second point that has to do more with the regulations. A lot of the regulations ask Carson City to put into its plan certain regulations of the certain clauses that regulate the practice of law. I will be the first to say that Carson City has no authority to do that. Moreover, if we were to try to enforce some of those, I believe that we would be running afoul of the Supreme Court's standards for indigent defense, which say that the appointing authority cannot control the practice of a defense attorney, the defense attorney's representation of an indigent person. So I'm not sure, even if they were in our plan, I'm not sure how we could ever enforce them. So in that case, I would simply encourage the board, if the board believes it's appropriate, to regulate the defense bar directly, rather than forcing Carson City to do so by asking that things go into Carson City's plan. The next point I'd like to touch on real briefly, Carson City has a group of people in the court clerk's office that are very effective at, I'm not going to say selecting counsel, but at assigning counsel. The folks that would be selecting counsel would be the Board of Supervisors when they select conflict counsel, DIDS when they select and qualify private attorneys, and the court clerk's office would then simply be doing the clerical function of selecting the next person on the list, or if there's a conflict, the person after that, to represent an indigent defendant. This is a group of people that has experience doing that, and we would like to use them. However, we have been advised that through NRS 7.115, that function, once it passes the state PD, must go to DIDS or its designee. And we've been informed that DIDS designee must be one particular person, and that person must perform those functions. This seems to be a little bit inefficient, because if that person is absent and we don't have the authority to assign counsel in some other method, then indigent defendants are simply going to be waiting for a week or more before their counsel is assigned, and that would cause havoc with our courts. We don't necessarily think that having the court clerk's office assign counsel violates Rule 21, because Rule 21 simply says that the judiciary shall not is not overseeing defense counsel any more than it's overseeing a prosecutor. And so the assignment of counsel isn't really overseeing anybody, so we think this would dovetail well with the with Regulation 21. However, to be for clarity, we've proposed an edit to Regulation 21. And we would the next point I'll briefly go through is compensation and expenses. Pursuant to NRS 7.155, Carson City must pay for indigent defense. So the idea of treating prosecutors the same as defense counsel is, while I don't oppose the idea, practically speaking, it's difficult to do. And this is because the check and balance on the prosecutor spending is the Board of Supervisors. The Board of Supervisors can simply tell the prosecutor no if he asks for more money, and he has to make his budget stretch across many cases. And in some cases, he may not have the budget to hire experts for a particular case. On the defense side, as it currently stands, the check and balance on the defense spending was the judiciary. So with removing that check and balance, the defense essentially has a direct line into the county's treasury, which we simply can't, we really can't permit, because Carson City can't operate its budget that way if it doesn't know how that expense is going to work, and if there's an unlimited access to that fund. So we would recommend simply that there be some, or ask nicely, I suppose, that there be some check and balance on the spending of, or on requests for compensation and expenses. Carson City has identified that consistent with the Supreme Court order, senior judges would be appropriate under the Supreme Court order for that, to do that. We've been in touch with the Supreme Court. The Supreme Court has authorized senior judges to do that function, and as the Supreme Court pays for the senior judges, that function would then be paid for by the Supreme Court, which would at the very least find a little bit of extra funds for indigent defense, or at least some extra funds that indigent defense wouldn't have to seek compensation for. Let's see. Finally, I'll briefly touch on some ethical considerations. When NRS 7.155 or 7.115 suggests that a DIDS or its designee must approve expenses, I'll merely note that DIDS is also overseeing the state public defender's office. So this would allow DIDS to ask this, essentially tell the public defender that they weren't doing a good enough job and that they needed to have more experts on a certain case, and then to approve the experts. I'm not suggesting that anyone in DIDS would voluntarily violate any ethical provisions, but at the very least, it is an appearance of impropriety. And ideally, those functions, the approval of fees and expenses would be separate from the oversight of the public defender's office. And so in that, again, we would simply request that the board consider the idea of independent oversight. Again, Carson City would suggest senior judges. That was something that was approved by the Nevada Supreme Court. In the end, Carson City has really strived to provide indigent defense competently and quality indigent defense to the people of Carson City, and we would. It's really important for us that we continue to do so. So if there's any, we would encourage you to consider the comments, and we thank you for your time and service on this commission. And if there's any way that we can help, please let us know, and we would be happy to help.
Thank you. So I wanted to let you go over because I just wanted to seem like you were on your way. And so I just wanted to let you get through all of it so we could actually just hear your full presentation. So
thank you for your indulgence.
Oh, of course. So I would like to, I mean, I'm happy to go to discussion, but it might be useful to first just actually let Marcy respond. I think, I mean, when I think about what it is that the department is, you know, the goal is to set standards, ensure adequate funding, and reflected in that are some other values like independence. Marcy, perhaps you could address, I mean, some of these are sort of more global issues that go to the department's authority, but it seems like for sure, some of the most relevant are this process, the role of judges in appointment and in appointment of counsel and approval of requests for expenditures within a case. So I'm hoping you could address that. And then also just funding by the county versus the state more generally, if you could just respond to that.
That's correct. So when we go, as you all recall, when we created Assembly Bill 480, which came into law, that created a lot of these changes that we're talking about today. And the beginning part of that, the distinction of selection of counsel versus appointment of counsel, was actually something that David Carroll from the Sixth Amendment Center recommended that the state of Nevada adopt. And Todd had provided some attachments for Michigan, which I think it's important to show that even in Michigan, there is independence from the judiciary, which is specifically standard number 5, which has been created by that department. So Assembly Bill 480 is to create that independence from the judiciary, which has been recommended by the Sixth Amendment Center and is also recommended in the Davis Settlement Consent Judgment. So when we made that distinction, we distinguish between appointment, which is a judicial function, and selection of that attorney who comes into that place. So pursuant to the law, that is either our department or its designee. We have been in discussions with Carson City about some possibilities of who could serve in that role. But the way that it was written and what was testified to at the legislature, the purpose of Assembly Bill 480 is also to create that separation from the judiciary over public defenders. And this is also consistent with Regulation 23, which discusses that a public defender shall have the same oversight as a private attorney or a prosecutor. So that's what we were trying to achieve with that. As for the costs related to these expenses, our department has been tasked with several requirements, one of which was touched upon by Mr. Reese, and we have been specifically told by the legislature in NRS 180.320 subsection D subsection 1 that this department must establish requirements for specific education and experience for public defenders to be in court. And what the purpose of these regulations that we've worked on so hard since 2020, is we want to ensure that the experience of that attorney fits the complexity of that case to ensure that they're going to be able to comply with that. We also have our maximum contribution formula, which is NRS 180.320 subsection 3. And how the legislature created this is different than what was done in Michigan. In Michigan, they are given a grant of money from the legislature, but the legislature, when they created this, they told this board to create a maximum contribution formula, which this board has done. And that maximum contribution formula is contained within section 16 through 19 of these regulations. So that's where we have put this together. Another issue that's been brought up by Carson City is they would like to have a court plan, an all-inclusive plan, not just specific to indigent defense. But our whole goal is to assist and request funding from the state on behalf of each of the counties. And what's needed by the state is the indigent defense plan to be able to reach those certain things. So I know that that was one comment that was written, that they want this to be an all-inclusive court plan. That's not what we're asking for from each of these counties. We are asking for the specific indigent defense plan that we can use to request the funding on behalf of Carson City. There's also comments where there's a recommendation that we bind the state of Nevada in some way. I believe that this board is aware that it's up to the legislature whether they approve of and fund our maximum contribution formula. So we are not allowed to bind the legislature in any way and tell them that a county has to pay only so much. Like was said by Mr. Reese, a county is required to pay for indigent defense. And what we will be asking for as this meeting goes forward is permission to go to the Board of Examiners and Interim Finance Committee to request those funds over and above the maximum contribution on behalf of the counties. Did I touch upon everything you wanted, Chair Trump?
Yes, sorry, I was muted. I think you did. I want to just entertain questions and comments from the board. Go ahead, Laura.
Thank you. Laura Fitzsimmons. Mr. Reese, I just have some questions because I got this morning, what Carson City submitted. I'm assuming you're aware that we need to adopt these regulations today. So I just want to make sure, has Carson City submitted a plan?
At this
I'm
time,
not seeing you on the list.
you're correct. At this time, what my Board of Supervisors asked me to do was that they did adopt the plan. The plan that they adopted is included in the materials that I provided. However, it is not on the agenda today. We have received an extension from Ms. Reba until the end of this month, I believe. And my board of directors asked me to come and talk to the board and see what the board wanted to do, and then if there's changes that we need to make to our plan because of the direction the board goes in, then we will consider those changes. However, to answer your first question, I do realize that it may be a little bit late in the game. However, we wanted to bring our concerns to your attention. I apologize. I would have liked to have been at the September 1st meeting to make comments. However, at that time, this issue is not on my radar. And
Okay.
again,
I get it. Sorry, I'm not calling you on the carpet. I'm just trying to figure out how this could possibly happen. Because you talked about the Indigent Defense Commission. You talked about separation of powers. Did you go back and look at the history of the Indigent Defense Commission and see that that was all done under the aegis of the Nevada Supreme Court?
I did.
Okay, and you still think that there's a separation of powers issue. We'll deal with that later, and you're aware of the Right to Counsel Commission, all those hearings. Were you at the DA's office then? Because I've never heard from you. I mean, I'm just sitting here, we've worked so hard. I got to tell you, the hardest working among us, other than Marcy and her crew, was the mayor, right? This was all in process long before last year. As Marcy indicated, we had to kick off some dates because of COVID, but this was all out there. So I'm just wondering now why, when we have this deadline, I'm not saying you don't make good points, you do make good points. I don't know because I don't have time to look at them. But one thing I have a specific question about, you said that the Supreme, I want to make sure I get this straight. You said that the Nevada Supreme Court has authorized the use of senior justices for the role of being the person who shuffles the cases off. And I'd like to get into that. Did you, who did you, I mean, because that we need to figure out. So
No.
how did that happen?
Now let me be very clear. The Nevada Supreme Court did not authorize senior justices to be DID's designee, if you will.
Oh, I thought that's what you said.
The Nevada Supreme Court did authorize the senior justices to review requests for compensation and expenditures of money from the defense counsel. So
okay, if you could just, okay, I understand that. You said senior justices, but you mean senior judges.
You're correct.
Okay.
I misspoke.
So,
Can I just ask the question here? Are you talking like in under 80 KT 411?
I'm not
more recent.
I'm talking about more recently. Our court administrator spoke with the court administrator over at the Supreme Court and said if we received requests for expenses from Indigent Defense Counsel, would senior judges be authorized to review those? And the answer we got was yes.
I really need to speak to that. I'm sorry, but I think I understand you, maybe somebody put you in a difficult position coming here today, but you have to understand that the Supreme Court, did you tell them it was in the context of these regulations, which were an outgrowth of the Indigent Defense Commission? I mean, that's kind of like one of these things that just flew in here. I'm not sure if that conversation happened, that the context was known. So I think maybe that's one thing, you know, and I'll be quiet. Thank you, Chair Trom, but I'm really uncomfortable with you saying that and without us going back officially to the Supreme Court, because that's a complete, I've been on these commissions for what, 3 or 4 years now. Ms. Forsman's here. The primary thing that the Supreme Court justices always said is a total separation between the judiciary and expenses. So is there something more you'd like to say on that, or can we just follow?
Laura, this is Joni Eastley. They were adamant about that.
I know.
That's you're right.
Yeah, I mean, we're all, see, we have a history here that includes deep involvement. I mean, huge commitment and involvement by the Nevada Supreme Court. I'm not sure your court administrator understood that history, nor am I sure that the AOC, I'm assuming what you're talking about as the head of AOC, understood the context. So I just think we should table that or put it aside, because other than that, you know, I'll be quiet.
Hi, my name is Max Cortez. I'm the court administrator for the First Judicial District Court in Carson City Justice and Municipal Court. I also assist Story County. I've been the court administrator for 15 years, and I've had the pleasure of being in the judicial system for 30 years. I did 15 years in California. So I just wanted to give you a little bit of my background. When Judge Russell and Judge Armstrong were on the Indigent Defense Commission, they said that Carson was the gold standard, that senior judges were recommended to review those expenses. So when I was approached by the city back in April of this year to talk about the Indigent Defense Services Plan that's required, I went to Catherine Stocks and asked her if Catherine Stocks is the state court administrator, and she conferred with John McCormick, who was at the hearing with Marcy Rebor, provided input with them for the support of the plan. And I did provide them and ask them if senior judges would be allowable to review expenses, because one, they have the background, the experience, the legal experience needed. There would be no cost to Carson City to be able to review those. And those judges are retired. So if the Carson City wanted to contract with them as attorneys, would that be allowable? If they contracted with them as attorneys to review the expenses because of their legal experience, they are retired, they could do a contract with them, but that would be an expense to Carson City. Carson City wasn't sued, so they don't get any Davis money. They're dependent on the IFC at the state to provide additional funding. So the request was, well, can they do it as senior judges? We have a senior judge that comes in weekly. Can they come in, review the invoices, and provide them for processing with an accounting clerk? And if they're here, they can get the file pulled, review the case, and be able to approve or deny those expenses. So I did speak with Catherine Stocks. She did review it with John McCormick, and they were in support of this. They said, absolutely. I sent an email to the city and said they could do it for free to Carson City, which wouldn't impose an additional expense to the city. So she was clear on my request. I want to make the board clear. And John McCormick was clear on the request. And it truly is to find an individual who has the experience, whether that's through contract. If that's through contract with the city, it's going to be paid through the city. That's an additional expense. But if it's done through the senior judge program, there would be no expense to Carson City. So,
so we appreciate
I just
that
ask one
clarification.
follow-up. Did John McCormick know that you were making this inquiry? I'm assuming this was like last week or something when you talked to John?
I have an email from Catherine Stocks. Catherine Stocks conferred with John McCormick.
Okay, so it was in the context of these regulations, which came in, you understand the timing. We now have a state law that mandates this. This is very confusing. Maybe,
So I think that.
And I want to say, I apologize for coming in late in the game, but we were advised, I got an email from Marcy back in, I want to say June, and then began working with Mr. Reese. And so I know this is very important work, but we are also doing we're implementing legislation right now in the courts. And so we are juggling a lot and working with Todd. So it is a very busy time. But we are concerned that the regulations that are for many counties that just have conflict counsel contracts that are not using the state public defender, it's really going to dismantle what we're currently doing with indigent services in Carson and in Story. State public defender is our first layer, as Todd has submitted the comments. And I want to say I'm very proud to represent the courts in Carson. We do a great job. We weren't sued. The city wasn't sued. Story County wasn't sued. And we're pretty much dismantling the fine oil machine that we have in place to try to jump through a lot of hoops. And I'm fearful. I've been in public service for 30 years. And I feel like as a public servant, you need to speak out. I am fearful that people will not have an indigent representation quickly as we're doing it now. And I'm fearful people will stay in jail and it will be delayed because we're trying to treat Carson City and Story County like the other counties that are only using conflict counsel contracts. I mean, our system works, and we were considered the gold standard. Judge Russell, Judge Armstrong, who were part of the Indigent Commission Defense, came back. They attended multiple meetings and said, you know, we're doing the good job. We are using state PD. We're the gold standard. And I really feel like we're tinkering with that gold standard.
So Ms. Cortez,
with all respect to all the work that the board's done, like I said, I'm coming in very late in the game. And I understand that you've done a lot of work. I was not aware of the September meeting as well.
So Ms. Cortez, we all really appreciate that clarification, as well as your experience in doing this work. And I do want to get to a few other comments. I see that Ms. Forsman has her hand up, but I did see Drew earlier. So let me just take Drew. Do you still have your hand up?
I do. Thank you, Chair Trom. Just a couple comments. I think some of the discussion around the judiciary reviewing expenses. Now, since we've, this has kind of been a 12-year project since ADKT 411, and AB 480 and the regulations have somewhat narrowed that discussion. But ADKT 411 did originally say that, I'm reading specifically, whereas the appointment of counsel, approval of fees, and determination of indigency should be performed by an independent board, agency, or committee, or by judges not directly involved in the case. So I think that's where Mr. Reese and Ms. Cortez might have, found that discussion with John about, as long as the judges aren't involved in the case. That's not our preference based on our regulations and now the statute, but just to give some historical perspective, back in 2008, that's what the Supreme Court did say. On a second note, I'm not as offended by Carson City's practice of, as long as Marcy's department approves the people who are put on a list, the court clerk technically is under I assume in Carson City, an elected court clerk, although they are in the court and with the judiciary, they're somewhat of a separate branch under the court clerk. At least that's the way they are in Clark County. And so if the appointment of the tertiary conflict seems to be the concern, because they have the state PD, they have a contract with a conflict counsel, but the issue seems to be this third tertiary conflict. If the people that the clerk is choosing from have been vetted by Marcy's department, I'm not as offended by that, because that's quite frankly what we do here in Clark County. We assign the attorneys to the courtrooms, and then the court rotates through those attorneys that have been appointed, as long as the appointment type meets the qualifications of the attorney that we vetted. So, I know Marcy's group, when they're considering applications, qualifies people at different levels. So as long as the clerk in Carson City is aware of what the charge is and the vetted attorney has been placed on the list, I don't see a huge problem with them reaching out to that lawyer, because they're just at that point appointing them. We're the ones who selected them for assignment. And so as long as they equally rotate amongst that list that Marcy's approved, I still think that appointment has come through us and not the judiciary.
I just so thank you for that. I'm going to get to you in just 1 second, Ms. Forsman. I just wanted to comment on that. Just a few sort of clarifications based on the statute as I understand it. I'm talking about AB 480, that Clark and Washoe in the statute are treated separately, so that the procedure for appointment of counsel, regardless of who's involved, is statutorily put in a different basket. And then regarding other counties under less than 100,000 in population, that the language, we're talking about two different aspects of DID's role here. One is, yes, DID's in a separate area identifies attorneys who are permitted to do this kind of work, but in specifically choosing which attorney will step in a given situation, it's the statute gives that responsibility to DID's or its designee. So it does not limit who the designee can be, right? So it's just that they get to choose. So that's a slightly different, it's not, to me, it may be that they could choose someone who's affiliated with the judiciary, similar to those, the way it's done elsewhere, but it is they get to choose language that was in the statute, just to clarify. And then of course, any attorney would be subject to approval by DIDS, because that's the way that the sort of attorney selection, attorney approval works. Okay, Ms. Forsman, please.
Yes, as most of you know, I was on the Indigent Defense Commission from its first day maybe before that. I don't know where the language gold standard comes from, but I wanted to make it clear that the Carson City and was not sued in the Davis case because we had determined that it was best to go after those counties that didn't have public defenders. And so the counties that were not part of the suit, it was not because we did some kind of assessment of the quality of representation or the services before naming the defendants. It was because Carson City and Story County were with the state public defender.
So I can only relay what Judge Russell and Judge Armstrong, when they came back from the meetings, what they relayed to me. That's the only thing I can relate to this board. One thing I do want the board to know is right now in our justice court, we have 4 full-time employees that review cases every morning, not one person. They review those cases. They identify if there's any active open cases. They pull all of those cases together. They determine if there's been a conflict in any of the cases, and then they flag that for the judge. The person is screened within 24 hours of arrest for their financial disclosure form, and then that's provided at the 72-hour hearing to the judge to determine indigency. That's a very fast turnaround period. It works very well. Our first stop is state public defender. That's our first layer. If the clerks determine that there is a conflict because they're looking at the other open cases, if there are open cases or if it's a co-defendant case, they flag that. They determine if that person had potentially a open violation on a probation case. They were represented by the state PD or by a conflict attorney or appointed attorney. Then when the judge appoints that case, they look at who has represented that indigent person in the past. This is Judge Armstrong's practice. I talked to him this morning about it, and he says he is doing this every day. So just so you know, when that person comes before the court, there's already been a screening, and they get the attorney that is going to best represent them quick. There is no other call to another department. And we have 4 staff doing this every day. We have hearings 5 days a week. We're not a small court. On Tuesdays, we have out of custody hearings where that process is also being done. So it's very important to know that this is a very quick process, a very efficient process. And the whole goal is to ensure that that indigent person receives quick representation. Our state PDs are at those initial appearances. They do a wonderful job for Carson City, have done for years. So I just want the board to know that it is very, very important that all of these regulations that are going to be passed for counties that were sued and for counties that were not sued, we're different. We use the state public defender's office. Our state PDs are in the courtroom. We're different.
Okay. I just want to move along to get some comments here. We appreciate that. And one of the sort of realities is that we are navigating new terrain, trying to do so with efficiency, obviously, by preserving efficiency, but we're also sort of realigning the way that systems work, which we realize is a big adjustment. So I want to go to Laura. Look like you had a comment, if you still do.
I just have a quick comment. We're an hour into this, and we all, thank you, Carson City, for recognizing that this just came in. We have a process, but we have got to approve these regulations today. We can get into, you guys were busy, but we've been working on this for a long time. In the process, after the adoption of the regulations, if there's a problem, you guys at that point, it's my understanding, somebody needs to correct me, but I just read, our material today. You guys can come back to us with specifics and facts, and we can spend our time you know, if Carson City's different, or if you know, if you guys can work with Marcy, it would be very helpful if you actually submitted a plan. But, you know, I just really am getting very concerned about the time.
Okay. I mean, it is true that we have been, this is a baby agency sort of launched in order to tackle this work. We've had statutory changes along the way. So a year ago, we, you know, received the comment that the statute required judges to do the appointment, and now we have a new statute. So we're really implementing that. And the regulation process is, of course, it's an ongoing dialogue where I know the department will be talking to everybody about their experiences and then fine tuning as we go along. So we will definitely keep that conversation going. I want to go to Bevan Lister and then Chris G. Oh, and then I see Justice Maupin as well. So I'll come to you after that. Thanks. Go ahead, Mr. Lister.
Thank you, Madam Chair. Process question. So we have in place temporary regulations. Do they expire?
Yes.
And if I understand that there's different timelines, is November 1st the last opportunity to submit permanent regulations before the next legislative commission process?
I don't know about the second half of your question about how long it would take if we didn't have regulations, but we had temporary regulations that we enacted in March, and sort of by definition, I understand that those regulations would expire November 1st, which is why over the summer we jump-started this process to make sure that we were going to have regular, permanent regulations ready to be in place by November 1st. Then if we were to pull those, I'm not sure if maybe somebody else could tell us what the timeline would be, but I think the timeline is very much up in the air because it took us, a long time to get to this point, which is why we feel pretty seriously about meeting this deadline and not derailing it now and having our regulations in place on November 1st. So I don't know, Marcy or Sophia, if you have Ms. Long, if you have a additional comment on
that. No, this is Sophia Long. That's correct. So your temporary regulations expire November 1st. If nothing's in place, then you just don't have regulations.
And you start over some process, but we don't know how long that would take. So one of the reasons that we've been mindful of this is, you may have recalled from September, we had a discussion, if we were to substantially revise the regulations, we would be off of our timeline. So we have been careful in terms of making, fine tuning the regulations, the proposed regulations, that we can still meet this November deadline. And one reason is that we have maybe 13, 14 other counties whose plans that we're going to approve today comply with the regulations. So everything is sort of built on that platform based on these regulations.
Understood. And I guess where I was headed is what are the implications if we re-adopt our temporary regulations without going forward with this permanent regulation?
So Sophia, again, you can't re-adopt temporary regulations because there's only a time frame where you can implement or adopt temporary regulations. We're in the time frame where you can only adopt permanent regulations.
And the temporary regulations, am I wrong about this, Marcy? The temporary regulations are mostly what our regulations are, with very minor adjustments, partly to reflect and incorporate the change in the statute that happened this legislative session, which, as we've talked about, cements this independent function, right? So that we are no longer having judges appoint counsel and approve public defender expenses in cases.
That's correct, Chair. They are pretty much similar. We did make some minor modifications, as I pointed out at the beginning of this meeting, of how there were clarifications at the workshop that came. And then at the workshop, we did describe some language that we had modified from the temporary, because as we were working with counties, we kind of realized that there's maybe extra language that didn't need to be in there. So before we sent it to LCB, with Chair Trom's permission, we did remove that language to make this more a smooth process. And the biggest one we modified is now section 38, the oversight, because we wanted to get more information before we actually developed that oversight regulation. But otherwise, they are very similar to the temporary.
Right. And just to reiterate something that we haven't gotten to, but will, that we've, all of the other counties, that are required to submit plans, they comply with the regulations in the sense that everyone is doing an appointment process that DIDS has approved. It's non-judicial and complies with 480 as well as the other laws. I want to go to Chris G and then Justice Maupin. And I'm sorry, Mr. Lister, please finish.
Well, if you don't mind, Madam Chair, just one other in the process question. If we adopt these today, and then we feel like there are some warranted arguments, and that amendments need to be made, what is the process or time schedule in that case? And then I'm done. Thank you.
Oh, that's okay. I think that's actually a Ms. Long question, which is if we were to, let's say we adopted all but one or two, or we adopted them all and wanted to change one or two, what does that time look like?
So you can adopt permanent regulations every other year.
Okay, so then this puts us on a 2-year timeline to make adjustments. And
right, that's what I would recommend. And then in the in-between, you can adopt temporary regulations, but you'd have to do this process. If you do temporary regulations, just as we did, you have to do this process twice.
Gotcha. Okay.
So any amendments would have to come in the short term as temporaries, and then we go back to that 3-month window in 2 years.
Correct.
Or you can just adopt them in 2 years.
Great. Okay. Thank you. All right. I think that it's Chris G, then Justice Maupin, then Jeff Wells. Go ahead.
Thank you. I'll be quick. I think in looking at part of our handout today, we had the list of the plans that were submitted. Story County did submit a plan. They had a corrective component, and then it looks like it's now been recommended for approval, if I'm interpreting the C and the A. No, okay.
The Story County is the only one that it's on that summary chart, but it's the only one that has not been recommended for approval. And my understanding is that Story Counties and Carson their plans are similar in all the important parts.
Okay. So let me ask this. Where is Carson City's plan?
We don't have Carson City's plan. They've got an extension until the end of October. And I know that Marcy and her team are looking forward to working with them because they've been working carefully with every county. So part of it is I think there's just a little bit of a delay in terms of getting this going. But that's where they are. We don't have a plan from them submitted, from Carson City submitted. They do have an extension until the end of the month, this month. And so we're looking forward to getting that. Story County did submit a plan that has not been approved. And so that's number 9 on our agenda.
Okay. So I think we're belaboring this conversation of trying to appease something when we don't even have the final document to take a look at to see if we've really thrown the whole baby out with the bathwater or not.
Well, just to step back for a moment, this discussion, I agree. I would like to wrap up this discussion and move forward. So I want to hear out some comments, but I think then we're going to move forward. And the reason that I had Carson City speak on the regulations is that Carson City doesn't have a plan, but they did want to weigh in on the regulations that we're slated to approve today.
Nope.
As an action item.
And I appreciate that. And I appreciate their comments that have been made. They're valid in their mind, but I think it was clarified that regardless of what happened when the original commission was on, that's gone. And this is the new one. And with no disrespect to 2 retired justices, thank you very much for your input, but you don't get to have a say on this particular DIDS currently. And maybe I'm saying what others may be thinking or not, but that's just kind of where I'm at this point. So I think we need to move forward see if there's any more testimony, go through the agenda on the rest of the items with regard to the actual regulations. And then we can, there still seems to be an available process down the road if there is a concern after we adopt the regulations.
Thank you.
You're welcome.
So let me get this straight. I'm not on the commission for the purpose of reviewing this agenda item.
No, I don't think she's.
I don't think so.
No, you are welcome to speak.
No, I was not referencing you, Justice. It was the reference to Justice Russell and the other previous justice that was being brought up during the hearing. Thank you.
Okay.
Go ahead, Justice Moffett. You had a comment.
Well, I wanted to go back to the comment that Laura made about the role of the senior judges in reviewing these fee bills. Everybody who's been around me for the last 10 years knows that I'm against the trial judge approving the billings and approving investigative measures, and that's all water under the bridge. But there may be as Laura points out, there may be an ambiguity in this conversation about letting senior judges get involved in this. The first budget that comes up at the legislature is the judiciary, and that's where all the, with all respect, Chris, it's been a long time since you were involved in this, and I'm not talking about you. They use that as a starting point to show what big percentages they're saving from the state budget, from a budget that doesn't have 5% of the general fund attached to it. So I think it might be wise to have a telephone call with the justice who is running the senior judge program, just simply to see whether or not this deployment would be funded out of the senior judge fund within the Supreme Court's budget, or whether it comes out of this budget. And because these kinds of ambiguities occur as you go up the bureaucracy into the court itself. So it would only take a few minutes, and I don't know if Justice Paraguri is still running the program, but this is something that can be handled fairly quickly, and it would probably be wise not to saddle the AOC with a decision that the Supreme Court itself would say implicates their funding versus the funding of this operation.
Thank you. Jeff Wells, I think you're next.
So first, I should just apologize to our new members for being stuck on such a long and tiring meeting already. And second, I'm not going to pick on Mr. Reese for being slow in submitting all of these things, although both Dave and Bevan and myself were up in Fallon last week, and we would have been happy to sit down and talk to these guys about all of this. That all being said, I actually am sympathetic, if I understand. I only got it this morning, and I had a 3-hour meeting, and so I've been speed reading it while everybody else has been talking. I am sympathetic to one of the concerns, if I have it correct, and I'm thinking that we did not think of this earlier. There are only a couple of jurisdictions that are actually using the state public defender at the moment, and that would be Story and Carson and maybe somebody else who escapes me. And so we talk about expenses for investigators, expenses for experts. Now, the state public defender's office is now reporting to Marcy. So if in fact I have a case that I have 2 defendants, and defendant number 1 goes to the state public defender, and defendant number 2 goes to a approved conflict counsel, And then defendant number 2 seeks an expert in a certain area. It seems like a conflict for that defendant to turn that request over to the same organization that is providing the defense for defendant number 1 to review and look at. And if that's the thrust of both Stories and Carson City's complaint, I agree with them on that. It's different than all of the other offices that don't use the state public defender, because then obviously bids can do it. Now, the way around that to me would be a relatively simple amendment. Don't know where it goes, but where the section that says that the expense approval will be done by bids or a designee, all we need to do is add a sentence that says, and they will appoint a designee in those jurisdictions that the state public defender is providing the first layer of defense. We're not then changing anything. We're allowing somebody else to do it. But I could see an argument someday being raised that the same outfit that is providing defense to number 1 gets to approve or disapprove the expert for defendant number 2. Now, Mr. Reese, you can tell me if I got your concern correct or not, and maybe I missed it, because I will admit I read your stuff very quickly in the last few minutes. But if that's the case, and we're already going to make some amendments today to the rules, I'm not trying to hold them up. We're going to make amendments today, changing section numbers around. It would seem we could add that one little sentence and solve that problem. But, you know, that's my thought.
This is Todd Reese. Yes, thank you for pointing that out. That was one of our concerns. We have additional ethical concerns as well, but that is one, because then—
Well, I'm not sure I bought all your other concerns, but I did buy that one.
I appreciate that. Yes, in that situation, you know, when you're supposed to have representation be separate for to co-defendants, it would essentially be giving, you know, one defendant the possible strategies of the other defendant.
And I would like to hear from Marcy on this, and also to point to the language, because one thing is we're not changing the statute. So I want to be dialed into the particular regulation that we're talking about where a change would be necessary. But it may just be that in reading the language of the regulation, we can just avoid conflicts in administering it. So I just wanted to turn to Marcy to sort of get a clarification on that, because—
That's correct. So I think, thank you, Chair, what Mr. Wells is referring to is actually law. That was our Assembly Bill 480, where it's the department or its designee. So I don't believe that we're able to modify at this point without going back to the legislature. What we would do, however, when we're talking with Carson and Story, is we are open to finding an appropriate designee for our department. We have not said that it necessarily needs to be one person. We have encouraged that it could be one person, because we would like it to be a resource for public defenders. As for Carson and Story, we would ask that they possibly consider for the Nevada State Public Defender that Karen Kreisenbeck is the designee for expenses within the Nevada State Public Defender's office. She could certify that all of the expenses are reasonable and necessary coming from within her office. She currently has 2 investigators that are used, and the only thing that she'd be requesting would be expert fees over and above the $2,500. I believe Carson and Story are recommending that fees up to $2,500 automatically be approved. So if we were to have further discussions, that would be something that I would encourage them to consider, that the designee for those expenses for the public defender could be the public defender herself. Anything outside of that, our department could cover, or we could find an additional individual to cover that. We just haven't been able to have these discussions as to who the appropriate designee is. When we go further into the agenda items, Mr. Qualls is going to talk about some of the requirements that this designee will need to perform. We are hoping to have them sign a confidentiality agreement. We would also like them to have access to our legal server for the transfer of cases. So I think that this discussion needs to move further so that there's a full understanding of what the designee would be doing. And I don't know if it'd necessarily be a conflict if the designee were Karen to approve within her office and then us to approve everyone else. That would be consistent with what Drew does and what Krista Meyer does in Clark and Washoe. So I would just ask that we go to the table and we have these conversations, which we haven't been able to have.
Excuse me.
It would not be,
If
I
I
was
could
just-
chime in here, because I've had conversations with Marie Ann Langer, Story County District Attorney. So one of the things that Story County has, we have 111 cases that are with the Public Defender's Office. 95% of our cases are public defender cases. We have 6 conflict cases a year. I have done every single case in Story County for the last 8 years. When you're looking at this, which is my biggest problem, the department, and everyone knows this, your group knows it, the Department of the Public Defender, State Public Defender used to be under Health and Human Services. But when the department, the Public Defender's Office, moved over to DIDS, Marcy is actually the boss of the Public Defender's Office, and she is the boss of DIDS. So when you're looking at everything that you say, everything as far as the independence that you're looking at, that the independence that you want, the thing that Ms. Reba has the ability to do through her case management system is if somebody from her office submits, a request for expert fees, right? And she looks at it and she says, I don't think this is enough. I don't think they're looking at this case close enough. She can actually go into the software program and read the attorney's notes, read what they're doing with the case.
That's not accurate. I'm
Well,
sorry.
okay, so so how do we distinguish her being Karen's boss and also head of DIDS?
Okay, I think we need to table this for the moment because we're getting into hypotheticals. We're sort of mixing in regulations and specific plans. And you're now we're sort of getting into a whole new area, which is sort of conflating independence from the judiciary with independence on a particular conflict case. And I think that is sort of beyond the scope of what's in front of us now in terms of taking action on regulations that have been in the works for more than a year.
Thank you. I just wanted to make sure I got that on the record because I think Mr. Wells just brings up a very important point because the only 2 people in the state out of all 17 are Story and Carson, as far as the fact that we have the public defender. That's what makes us different, is that we've got this issue that nobody else has. So I just wanted to make sure I got it on the record, and I'll stop there.
Thank you.
And two things. While I was suggesting it be a designee, I was not suggesting the designee be judiciary.
Right.
That's number one.
Right.
So, and then.
Right, I get that. I get that part.
And then number 2, it's not exactly the same as what we do down here. Clearly Drew appoints or approves experts, or I do when he's not around, approves experts and investigators. But to the extent that we buy the argument that Marcy is equivalent to the State Public Defender's Office because it reports directly to her, then it would be more like we would have Darren Emily approving for the defendants being represented by people in Drew's office. And that is the inherent problem that I actually was seeing. And so I know we're not changing the statute. I thought we could appease both Carson and Story with a fairly minor amendment that simply says for those expenses for investigators and experts, when in those counties or counties that are represented by the State Public Defender, that they will pick a designee outside of that system to do it. I don't care who the designee is. I'm not suggesting it be the court, however.
Right.
Franny was on the earlier commission from the beginning. I was on it from 2 days later, so.
Well, I appreciate that, but I think that the reality is that is a plan decision that can be worked out at the plan level and is not necessarily require a change in regulations, because I think the real sticking point is whether that designee is the judiciary. If we move off of that and we're going to who it is that DIDS is going to designate, that will take into account the local situation of having a public defender and then who could step into that role. And so that is then a plan-based sort of county by county decision. That's at least how I understand it.
Thank you. I really appreciate that clarification.
Okay, so any other comments? I think that if we could conclude number 5, which is our discussion of the regulations, unless there's an objection, I would like to move on to number 6, which is adoption of the regulations. So this would mean, this is up for possible action of adopting the revised proposed regulations of the Board of Indigent Defense Services. These are the ones that we workshopped on September 1. We've now had the requisite, I think it's 30 days plus to then have this meeting to adopt them. I'm open to any specific discussion on this, but I'm also open to a motion.
Madam Chair, I'd like to make a motion. I would move that we adopt the proposed regulations with the 2 minor amendments that were noted by Marcy at the beginning, section 28, changing 28 to 37 to 30 to 40, section 29, changing section 28 to 37 to sections 30 to 40.
And there might have been 2 other, that includes the changes that were noted by Ms. Reba. Okay.
That is my understanding of the changes, which I actually wrote down at the time.
Okay, so it is both the numbering as well as the minor substantive tweaks that were incorporated based on our September 1 meeting.
This is Chris, I'll second.
Mr. Lister, do you have a comment?
Thank you, Madam Chair. If you've accepted the second, I have a comment I'd like to make.
Okay.
So are we there?
Yes.
Okay, thank you. I appreciated the comments submitted by Carson City. I have struggled. Of course, I'm new enough to this, and just a dumb farmer and a group of really intelligent people. It's been a struggle to try to catch up, but in our hope here of trying to trying to minimize the challenges to the counties to fund and take care of sound public defense, and have the state take and shoulder some of that responsibility and cost. What we've done is just develop a whole new layer of government and a whole nother set of costs that go along with it. Understand that there's a formula out there that says Lincoln County is only going to have to pay this maximum contribution amount, which is good. But then there's some reporting requirements and some other requirements that come back to the county that are going to cost, whether it's in time or money to hire somebody to do it, or out of my time budget, or however that works out. I don't know, but my concern is that for the rural counties, yeah, we're headed. I think we have a desire to do something good here. I have some concerns that the regulations, one, like I told Marcy earlier, I've dealt with the LCB over a long period of years, and I realize they get paid by the word, so there's always about 10,000 more words that need to be there. They could, I think, be significantly simplified. I think there are some challenges like that Carson City has enumerated, and that I feel like we're going to have to address down the road. That's why my questions earlier and related to process were along the lines of, now we're going to have to start the process of molding this in a direction that it needs to be to make it simpler and more effective for the counties. Because that's one of my biggest concerns, is that with the goal of trying to make it more effective and getting better public defense from the counties, we've just put more requirements on them. So I'll leave that thought with the group. Thank you very much.
Thank you, Mr. Lister. So as it stands at the moment, we have a motion that's seconded. I'm inclined to take a vote. So all those in favor who can vote in favor of voting in favor of these regulations as moved with the minor edits, on numbering that we, and outlined by Ms. Reba, say aye.
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 Anyone opposed? Hearing none, the regulations carry. So thank you very much for that robust discussion and for the comments. We really appreciate them. Okay, I'm going to now, we're on to agenda number 7. I'm going to turn it over to Tom to just say a word about the appointment of department designee.
Sure. Thank you, Chair Trom. Obviously, there's been a whole lot of talk about this already today, so I don't want to retread any ground, but I just want to clarify a couple of things about the designees. We'll be asking the board to approve a number of these county plans, and those plans will necessarily include the designation or that will necessarily include someone to fulfill the role of selection of counsel and of approval of defense fees, and whether that is our department or its designee. Just to back up and clarify, AB 480 was introduced and was drafted, introduced, and passed this last year by the legislature, and its primary intent was to create a measure of independence for indigent defense from the judiciary that is on par with what the prosecutor enjoys. That basically, oh, and also the Supreme Court is on record in supporting that in this year's process, supporting its passage. It essentially involves 2 levels. That is, as I mentioned, the selection of conflict counsel and then the approval of attorney fees and expert expenses. And those were codified. The selection was codified in NRS 171-1884 and also in NRS 7.115. And then the fees and expenses are codified in NRS 7.135 and 7.145. There in the plans, you'll see that there are 6 counties that have elected to use DIDs for this function. And then the rest of them are creating their own designees. Well, they're creating their own council coordinator, appointed council coordinators that will be approved by DIDs as our designee. There's a number of different functions that didn't exist before. Again, sort of all of these things are interrelated. And one of the things that's interrelated with these 2 functions is the reporting requirements from Davis. In order to collect, as we were mandated, uniform statewide data on caseloads, hours, resolution of cases, et cetera, we selected the case management system legal server and have provided that to all of the counties and the practitioners. Since June, we've been in the process of training and supporting and onboarding this. But I'm only telling you that to say that that system is integral in both the intake of the cases and then the transfer of these cases to conflict counsel. As you can imagine in this process, whoever's in the chain of this has at least temporary access to potentially some sensitive information. So we have been in consultation with the AG's office and with Chair Trom and UNLV, including ethics professors there. So anyway, we're in the process of creating a confidentiality agreement that would cover us, that would cover any appointed counsel administrator, i.e. any designee that fills this role. And then also creating terms for that position in which they would have to comply with all of the DIDS regulations. Again, this is an ongoing process. but it's a little bit complicated. That's one of the things that hasn't been part of this conversation about whoever steps into the role of this designee will have to be part of that chain of collecting this data and oftentimes, inputting these cases. One reason, in addition to everything that's been stated, that it's sort of inappropriate for the judicial system or probably even the clerks to be designated is that, again, they'll have to either be doing the case input or be in the chain of transferring these case files to conflict counsel. These are all considerations that we're having to weigh and try to weave together. Marcy can tell me if I forgot anything there, but otherwise I'm happy to answer any questions, or she can if anyone has any.
Chair, I don't have anything extra. I do want to clarify that we cannot see what's in the information. We cannot see what's in the legal server files until it's transferred to our office. So even though we have oversight over the public defender, arguably within our statute, we cannot see any of their cases. And we just wanted to clarify that. However, when a case is transferred into that legal server system, that individual will have access to that information to transfer it on to the new attorney so that we can track this information and ensure that this information is staying with the case. So I just wanted to clarify that.
Okay, thank you.
In this process, we have removed ourselves from sort of a super user down to a regular user. There's one person in our office who, with any office's permission, if they have a problem, with their permission, he will go in and help them fix whatever the problem and get back out. But our office does not have the ability to go into these cases, read any of the notes, or access to any sensitive or confidential information.
Okay, thank you. So unless anyone else has comments, I think we should go on to the number 8, which is the county plans and budget approval. And as you could tell, I'm going to let Marcy shepherd. This is a lot of information, which I think Marcy is going to be able to shepherd in a and explain in a very efficient way. So take it away, Marcy.
Thank you. So before I start getting into the specifics of the plan, I do want to call out the individuals that we have been able to work with when we have been working on these plans. You will see that we are recommending approval of several plans. In Churchill County, we worked with Jim Barbie, the county manager, Jacob Summer, the public defender, and Commissioner Pete Olson to put this plan together. In Douglas County, their plan was to put together by Patrick Cates, the county manager, working with our office. Elko County put together Cash Miner, who's the assistant county manager, Amanda Osborne, who's the county manager, Matt Pennell, who's the public defender, and Rand Greenberg, who's the chief civil deputy district attorney. In Esmeralda County, we worked with Robert Glennon at the DA's office, Jason Ernest, who is the acting public defender, and Judge Johnson, who is the justice of the peace. In Eureka County, we worked with Kelly Brown, who's the public defender, as well as Judge Dorothy Rowley. In Humboldt County, we worked with Dave Mendiola, who's on this board, and also the county manager for Humboldt, Matt Sturmitz, who's the public defender, Maureen McDonald, who is with the public defender's office, and Derek Penny, who is the alternate public defender. In Lander County, we worked with Judge Shirley, Bert Ramos, who's the county manager, Ted Herrera, who's the DA. In Lincoln County, we met with our board member, Bevan Lister, as well as Franklin Katchke and other individuals from finance for that county to put this plan together. In Lyon County, we met with Jeff Page, who is the Lyon County manager, Eric Malavsky, the Lyon County human resource director, and Josh Foley, who is the Lyon County comptroller. In Mineral County, we worked with Judge Shirley, Sean Rowe, who's the DA, John Oakes, who's the acting public defender, Carl Hyland, who's the acting alternate public defender. And in Nye County, we worked with Lorena Dellinger, the assistant county manager. And finally, in Pershing County, to get the finalized plan, we did work with Judge Shirley, Bryce Shields, who's the DA, and Steve Cochran, who's the public defender. So in order to get these plans prepared today, there were some last minute changes, and these individuals worked extremely hard to get the plans where we needed them today for approval. We've put together a sheet that we've provided to all of you, which is a table with check marks that will show the regulations that were required to be addressed in each plan, and we'll check off whether or not the plan meets each of the requirements. It'll also designate whether that county is proposing an appointed council administrator with an A, or if they are requesting the department to do this with a D. And then ultimately at the end, we have our recommendation. A is for our conditional approval today, and CA is for corrective action because we need to work on the plans a little bit more. And without going into specifics, unless there are specific questions, for the agenda item, we have broken up these plans for Davis County plans and non-Davis County plans. For the Davis County plans, we are recommending plan and budget approval, and we're asking that you make it subject to the Board of Examiners and Interim Finance Committee approval. For Esmeralda County, Eureka County, Lincoln County, Lyon County, and White Pine County. And we are recommending plan and budget approval subject to BOE and IFC approval, and also subject to approval of the proposed designee by the department. For Churchill County, Douglas County, Lander County, Mineral County, and Nye County. And did you want me to continue? Chair Trom, do you want me to continue moving?
I think I'm just actually wondering if we should just approve these as we go in the sort of batch by batch. So this one, there's, I guess, 10 counties that are in this. These are the Davis counties. They're all of their plans check out. Some of them have a proposed designee that you would then approve. And then there's these requests for funds. You wanted to say one thing about that, and then I think we could actually approve all of these, this whole batch, and then move on.
So for the Davis counties, as you are aware, we did receive 1.2 million approximately that was earmarked in the Interim Finance Committee contingency funds. In working with the counties and asking for how much they budgeted for their plans, we would request permission to request $1,124,427.14. We will be reducing this amount because we looked at the maximum contribution formula, but after speaking with the governor's finance office, we need to take our numbers for the maximum contribution formula and add inflation to them. So these numbers may be reduced after we add inflation as set forth in the maximum contribution formula in section 16 of our regulations. And because that request will use up basically the funds that were set forth or set aside by the IFC contingency funds, the Davis counties need additional funding to comply with their plan. And we are requesting permission to seek that additional funding from BOE and the IFC contingency fund in approximately $1.7 million. This amount has increased by $200,000 after we received additional information from Douglas County about their appointed council administrator and other expenses that they were expecting as part of their plan. So these numbers may change as inflation is reduced from that amount, but we are requesting those items.
Okay. I actually am just changing my mind. I think we can get through all of these counties and then have a vote, but go ahead, because I realize it's not too much more. So Mr. Wells.
I was actually going to take your first approach and make a motion for all of 8A and
fine.
And move on.
Let's do that. Let's do it. So unless there's someone else, so does someone want to second Jeff's motion? Let's just do it that way.
Yes, this is Joni Eastley. I'll second that.
Okay, thank you. So we have a motion to approve all of the, I think I counted 10 counties, all of the counties listed in 8A, which covers what we are calling the Davis counties as proposed here. All in favor, say aye.
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 Anyone opposed? Thank you. So that carries, and let's go on to now, Marcy, you can talk about the non-Davis counties. Thank you.
Thank you. The non-Davis County plans that we have received are from Clark County and Washoe County, and these plans were previously approved by the Supreme Court in 80 KT 411, so they meet our requirements. So we will be asking for Clark, Humboldt, and Washoe Counties plan and budget approval subject to BOE and IFC approval. We are recommending that the plan and budget approval subject to BOE and IFC and subject to approval of the designee for Elko County and Pershing County. And we are requesting permission to seek from the Board of Examiners and the interim finance contingency funds approximately $3,644,980.66. And again, that amount will be reduced by inflation.
This is Joni Eastley. I'll make a motion to approve that.
I'll second.
Chair Trump, but before we vote, I had a quick comment. Considering that the money that we really want is for those Davis counties, does it hurt our request to include funds based on the formula on Clark and Washoe's budget when neither Clark or Washoe are probably really going to request those funds?
That's actually a good question.
I don't think it, I mean, somebody else is welcomed. I welcome comments on this. I don't think it does. I mean, we do operate separately sort of from the governor's budget request and process as a board, but does anyone else have a comment on that?
Chair Trauma, I'm sorry, I'm not part of your board, but this is John Eric Scott. I'm the Washoe County Public Defender. Regarding the budget, is that related to the reimbursement funds that are referenced in the regulations? Because it's my understanding that our assistant county manager, we decline the reimbursement funds.
Marcy, do you want to speak to this?
And Chair, I didn't think it appropriate for our department to recommend to not move to seek funds from IFC and BOE on behalf of a county. We did have discussions with the governor's finance office. There is approximately $6 million that's set aside in the interim finance committee contingency fund. So if we do request that $3,644,000, the largest portion of that is for Clark and Washoe County. So if we took those requests out, it would significantly reduce our request by about $3 million.
I just threw it out there, Chair, because you guys have more experience with dealing with IFC, but that's such a big number in the percentage of what's available that are we more successful asking for those counties that are in more need, as Commissioner Lister said, some of these concerns of the expenses with the hope that the IFC does, that we want to make a big push that there's a real need in these counties for funds.
I mean, I understand that. I don't think that we're tying the department's hands at all by signaling, by doing this as proposed. So I'm really going to defer to you, Marcy. I don't think we're hurting you, because if you're not going to ask for the money, you're not going to ask for the money. And I think that that's the end of it. But
the risk that I see of taking that 3 million out at the moment is we may go to the IFC asking for 3 million, and they may decide because of other requests and other interest, they only give her $1.5 million. They cut it in half. If we ask for all 6 and they cut it in half, you still have 3. And you know, I don't know what other requests are going to be there. I think we can make these decisions after we see what IFC says, as opposed to chopping out half the money to start with.
Chris G.
Yeah, Jeff and I are on the same plate on that.
Okay.
Don't not ask for what you believe you need. Make the argument. You know, you have a fallback, but don't ever signal that, in my opinion.
Okay. So with that, let's maybe I can just actually take a vote on the motion that's been proposed in second, which is just to approve what Marcy outlined in terms of the county plans with the budget.
I'd just like to say that if my life in that environment has any meaning, that Jeff and Chris G are absolutely right.
Okay, so all those in favor of the motion, say aye.
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 Anyone opposed? Okay, thank you very much. So that carries. Thank you for all of that. Marcy, let's move on now to number 9. And is that Tom? Is that Tom? Okay, so Tom, why don't you address item number 9 regarding Story County's plan?
Thank you, Chair. So as has been discussed, Story's plan and Carson's plan is similar. The difference is that Carson withdrew theirs, asked us not to bring it to this board so that we could continue to work with them. But Story's is approved by their county board of commissioners, and it is properly here. So given that, we, our only decision is to recommend corrective action. Corrective action sounds, really punitive, and it's really just a big way to say we want, it's a formal entering into the next phase of this process of we want to continue to work with Story County and with their board of commissioners in order to bring this plan into compliance. The board, and it was attached to the agenda, has a summary of why, and it goes into the pages and the regulations at issue. I will just summarize by saying the first thing is that we don't have a budget. We don't have a final number, and without that, that potentially, among other things, it hampers our ability to request any funding for Story County. It's a requirement of the plan, so that's one thing that needs to be fixed. There's a problem in a couple of places as far as judicial oversight. We've talked about this a bunch today already, but it has to do with selection of counsel, approval of attorney's fees, and expenses. They still have judicial oversight in their plan. There's some missing language in a couple of places, including initial appearances and what counsel's expected to be prepared for there, as well as standards of representation under our regulations. It's not clear as far as timely screening. There should be a 48-hour screening requirement for indigency. The plan additionally allows for the county to go to attorneys to appoint conflict counsel that are not on our approved list. I think that covers all of the things. So we would love to just continue to work with Story County in this formal corrective action process in order to remedy those. Again, we are here, as we've discussed before, to get creative with them and to try to figure out solutions that will work for their county. And as has been discussed within the parameters of DIDS supervising the State Public Defender's Office.
Thank you. So Mr. Wells, I want to hear from you, but then I also want to go back to Ms. Langer since I did offer her the opportunity to speak now. So go ahead, Mr. Wells.
Thank you. I'm going to suggest that we not do this. Carson City and Story basically have the same issues. We've already agreed that Marcy's going to continue the discussions and negotiations with Carson City. I see no reason why she can't do with both Story and Carson City simultaneously. We can entertain both of them at the same time whenever they come back. This is a whole brand new board. This is the first round of submissions. I really don't want to start off doing corrective actions against anybody, particularly since we know there's going to be ongoing discussions. That would be my recommendation.
So in other words, not to think of this at all as an action item, but just an update that that DIDS is continuing to talk with in productive discussions with Story County and Carson City County, and we'll look forward to entertaining those plans when they're back.
So
You
does
said
that
it
mean-
much better than I did.
I think Ms. Langer should be heard on this because I think she was well aware of this process and wanted to move forward with what they had. anyway. So I would
So-
like to hear from her and see if she's amenable to taking that off the table, so to speak, and just continuing to work.
I just would like to bring up a few points because I think this board is very interesting. You're very well invested in what you're doing. And I think when you're just working with one person and you've got an entire board, there's things, you know, being a prosecutor, when I'm looking at this plan and you're looking at the initial appearance or you're looking at the vertical prosecution, those are things that the initial appearances are going to be, I would think, subject to DIDS. If DIDS finds out that, you know, somebody hasn't made it for an initial appearance, and that's one of the requirements that DIDS has, that to be, you know, part of it, that's not more a plan where I'm going to call downstairs to the county manager, Austin Osborne, and say, hey, the defense is not here at this this initial appearance. How are we supposed to enforce a plan when we are not part of the program? That's one of the things. So it could be included in our plan, but we have no rights to enforce that. It's beyond our jurisdiction. Same for vertical prosecution. You've got the public defender's office. We work with, like I indicated earlier, indigent defense cases. We've got 111. We have 6 conflict cases. These 6 conflict cases we have, everybody is DIDS approved. So everybody that we've used for years, there's one person that didn't sign up for DIDS, but everybody is on our DIDS list. So again, we've you know, we're looking to comply with that. I think one of the biggest, and then vertical prosecution, what are we supposed to do that now the public defender's office, somebody's sick that has the case? Does that mean we have to wait until that person comes back from illness, or can they go to the next person in the office and take over somebody's workload? These are things that I don't understand that you want in a plan that we can't enforce as a county. Have Mr. Osborne up there, you know, saying these things. It has nothing to do with the judiciary. The next one is, and this will be the end of it. So now you're looking, this whole thing started because Miss Reba and I worked together for 6 years. She was the defense attorney as I was the prosecutor for the first 6 years. And it's changed since she went to DIDS. Before that, she was the only one basically that I dealt with. So now you're looking at the county budget. And you've got the county budget, as everybody knows. And when we're looking at, the defense wants to enjoy the pleasures of, or what the prosecution gets. Well, what I get as the prosecutor is that I have checks and balances. I go in and I have a budget and I have to stay within that budget. I don't get to just say, oh my gosh, I've run out of money. And so therefore I'm going to go back and get a augmentation. They can just tell me, my board can say no. So now when we're looking at the original plan that did sound like a great idea, where all of a sudden that, and we're not part of the Davis group, Carson and Story are not part of the Davis group. We didn't have any money that were, you know, coming to us. We're working with the public defender's office. And so we've always had a line item, number one, to pay the public defender. Then we have another line item to pay the expert fees and costs and all those things that we've done forever. And now we're required, it looks, that we're supposed to estimate what our costs are, not what they are, because we might get paid back by the state, which has not funded this program. So virtually we are the ones that are paying for this. We're required to pay for it. So we're just saying, why do we have to estimate what we have when we don't even know what it is yet? Why can't we just pay like we always have? Because one of the things when I talked to Ms. Reba about this, I said, well, I don't think we're going to get our money back. So why don't we just use the same plan that we pay you when there's been services? And you know, when we were talking about that, she said, well, the way that you can get it back is sue the state. And the last thing we're going to do is sue the state. So those are the big things that we've had the problems with. I agree that we can move it forward to the next hearing. But these are the things, and I understand what everybody is saying about the judiciary. We, Carson and Story really believed that former judiciary under the ADKT 411 was something where you could use former judiciary. We're going to have to look at these things again based on these discussions today. I appreciate all the information I've gotten. I appreciate this board for what you're trying to do. We're not trying to get around some problem with indigent defense. It's a huge part of our society. But at the same time, to not have, you know, for the, it's almost like an unfunded mandate where as far as the budgetary portion goes for Story County, there's never been an issue of us paying. But when you're trying to predict something that you're never going to get back, that's part of the problem that we're having as far as our budget goes.
Okay, thank you. So, I mean, we appreciate your being here, and there's been a lot of robust discussion, which I wanted to give, you know, sufficient time so that people really understand in context what your perspective. I do think there's a proposal not to take action on this, but to sort of send you back for more constructive dialogue and working together. So I'm hopeful that that will come of this.
Thank you.
And with that, I think, unless anyone's opposed, my inclination is to just move on to number 10.
Well, are we
go
going to be
ahead, Laura.
set next month?
I'm sorry, what?
Are we going to be set, sorry, Laura, are we going to be set on the agenda next month to address this, or?
It sort of depends on the status of where things stand, but we're hopeful that, I mean, I know that Carson City for sure has an end of the October deadline. These, I assume that these are going to be sort of in parallel talks because they're so interconnected and similar. And then our meeting, which I'll talk about in a minute, is in the middle of November.
Okay.
So we haven't created that agenda, but we will do that.
Thank you.
Sure. Laura?
I just wanted to ask Marcy. Marcy, after hearing Ms. Langer, I always agree with Jeff Wells, but I'm not sure I do anymore. I think we're on the cusp. So I know, sorry, but I think we are on the cusp of a corrective action. You know, this issue about the independence of having senior judges, I almost feel like Ms. Langer hasn't read NRS 7.145 and recognized what the state law is that we're trying to implement through the regulations, and also that Ms. Ryba is trying to get you guys to agree. You know, the whole concept of DIDS is that your contributions are capped, and it's hamstringing your county and Carson City if you don't get a plan in quickly and you don't get an estimate of what the amount between your cap and what the total amount that's going to be required. It's going to hamstring your county and Carson City from being included in the IFC request. And we do need to be in compliance. So, you know, I don't want to, I mean, we all get along here, but in terms of timing, I think if Marcy felt comfortable having the same deadline as Carson City has to meet and come to an agreement and work out a plan that DIDS can approve, and then if not, I would very much ask that this be agendized for a vote on corrective action.
Thank you. I think my hope is that we can come back and approve compliant plans, but yeah, we'll see how they go, and we will agendize whatever we need to for November, I think is our goal.
So
okay.
One last question on that. I'm really interested about corrective action, because I've been looking to see, so we do corrective action, and we've learned a lot here that I'll go back and talk to my county about. But if you come back for corrective action, what happens next? What's the next stage that the DIDS board would do to you if you say, no, we're not going to correct that, or no, we don't have our plan in? I'm just kind of interested to see what the procedures are after that.
I don't know if we have that specified.
Right.
Tom, do you want to answer that?
Chair, what I can answer is if we are unable to come to an agreement on a corrective action plan, then ultimately the board is the one that would decide what the plan would look like, this board. We would take that to interim finance. It sounds like there's a different formula. So instead of being a maximum contribution plus inflation, what the formula would be is what Carson City or Story County actually spent last year or budgeted for last year. And that would be what anything, we would request anything over and above what was previously budgeted for the prior year. So I think that it could possibly not provide as much funding from the state if it's a corrective action rather than an IFC request pursuant to the maximum contribution formula.
Okay.
Thank you, Ms. Reba. I really appreciate that. Thank you, everyone.
Thank you. So on to agenda item number 10, which is an update from the department, some of what we've done, but Marcy, why don't you fill us in on anything we haven't covered?
Just a quick update. You've seen Nancy Paulson, who's the county manager for Carson City, Max Cortez, Todd Reese. These are all the individuals that we've been working with to try and create the Carson City plan. There was a request to extend their deadline until the end of October because the mayor was going to be unavailable for the October 7th board meeting. And my understanding is that their plan will be agendized for the October 21st board meeting. We have a meeting scheduled with them via Zoom on October 12th, and we're hoping to get this plan in place so that we can get it in front of the board at the next board meeting. And we'll be reaching out to Ms. Langer and Austin Osborne from Story County to schedule a similar meeting to try and get their plan moving forward. So that's the update as to the county plans and the recommendations. We have submitted our request to be on the Board of Examiners agenda for what was approved today. The deadline was today, so Carson City and Story County, we missed that deadline for them, so that'll have to be pushed off for the future at the next board meeting. I wanted to let the board know that we have released our request for information for our data analysts. There is a deadline of October 15th, and we will use that information to go in front of we'll request from the governor's finance office funding for a data analyst so that we can do a salary survey and also review whether or not we can create a pipeline to get attorneys into the rural counties, and finally to review our oversight. So those are the updates from the department.
That's great. If it wasn't obvious from my sort of what I've said so far, I just wanted to compliment the department on the enormous amount of work that sort of that has gone into today and goes into just all of this. There's so much outreach, so much coordination. There also have been, there's all very time sensitive because of regulation deadlines, interim finance deadlines, Davis monitoring deadlines, which are just being adjusted to make room for this. So it's just not only a huge amount of work, but very time sensitive. And we just are so grateful for the amount of teamwork, but also just outreach and very detailed work that you've done with the counties. So thank you so much for that. Okay, let's move on to looking to future meetings. So we had originally had a meeting set on October 27th. We're going to cancel that meeting because we're having today's meeting, and we will then plan to meet in November, in the middle of November. November 17th, we have slated, I think this is already an identified meeting date. So November 17th and December 15th, 2021 at 1 p.m. Those meetings are already calendared, but beware that Cynthia Tanasio will be sending out Zoom links and maybe canceling team meeting links. So don't be confused. Our meetings are as planned, but the platform we're using has changed, so that, don't be fooled by that. And you can look out for those. And then our January meeting will be on January 26th, and our agenda says 2021. It's obviously 2022, also at 1 p.m. If there's the possibility of not having the December meeting, we'll let you know. But for now, we wanted to keep it on the calendar so that we can address whatever needs to be done then. Okay, I would like to open it up for public comment. If anyone is with us and would like to make a public comment, we offer 3 minutes of the floor to make that happen.
Chair Trom, if I may, this is Todd Reese with Carson City. I'd like to make a very brief public comment.
Sure.
First, I just wanted to thank the board for their consideration and their hard work. It is always difficult establishing new regulations and a new regulatory scheme. In this, as in many other areas, Carson City, I believe, misses Mayor Crowell. We miss his guidance on this particular issue. I also wanted to, the last thing I wanted to say is that there was a comment that the county's contributions are capped. If our contributions were actually capped, that, I think we'd be having a little bit of a different discussion. But the county's contribution is not capped. Essentially, we're spending it and then looking for reimbursement from the state. And the state can choose not to reimburse us. So if we don't get reimbursed, we're stuck with the expenses. And with that, I'll wrap it up.
Thank you so much. We are, of course, very mindful of the funding scheme and would have been extremely happy if we had had the whole thing funded. That would make it more secure for everyone. But I think part of the reality is that we're a new agency and a new board and building this piece by piece. So hopefully over time, we will make the case that this is a viable way to do indigent defense and with everyone's buy-in and also the state's full support. So we're working on that. Thank you. So any other public comments? Okay, so with that, I don't think I need a motion, but I'm going to adjourn the meeting. It's always so
And I always move to adjourn.
I know you do. Is there a second?
Oh, sure, I'll second that. It would be my pleasure.
Everyone in favor of adjourning the meeting, say aye. And I'm not going to give any opportunity for opposition. Thank you, everyone, for your attention. Thank you to Carson City and to Story County for showing up and being part of this. And we wish you well as you move forward. And until next time, thank you, everyone.
Thank you.
Great job, Chair.
Thank you.